Hello, everyone, and welcome to the Prince George's County Bar Association and the Metropolitan Washington Employment Lawyers Association's January webinar. PG Tips, Navigating the Prince George's County Office of Human Rights and Circuit Court. I'm Scott Oswald. I am MWELA's Bench and Bar Committee Chair, and I will be your moderator for today's webinar. Before we begin, Michael Adams from the Prince George's County Bar Association has some opening thoughts for us.
Yeah, thank you very much, Scott. I want to welcome everybody today on behalf of the Prince George's County Bar Association, and thanks Scott and MWELA for putting this event together. For those of you who are not members of the Prince George's Bar, I would encourage you to go on our website, pgcba.com, and get more information about us. Put on a lot of great CLEs and social events throughout the year. Really, I think, allow people an opportunity to get hooked into the Prince George's County courts, network with people in the county. We have a few events actually coming up in the next few days that I want to make people aware of. A nuts and bolts of district court practice put on by some of our great district court judges here in the county is actually going on today at 5 p.m. That information's on our website. And then this weekend, we're doing a young lawyers social event. We're doing bowling out in College Park. That information is also available on the website. So please, if you have any questions about our organization, feel free to reach out to me. Take a look at our website and hope to see you very soon. Thank you, Scott.
Michael, thank you. And now to our participants in today's roundtable. The Honorable Peter Killough is an associate judge on the Prince George's County, Maryland Circuit Court. Before his appointment, Judge Killough served as an assistant attorney general for the state of Maryland for 9 years. In that position, Judge Killough led the state of Maryland Medicaid Fraud Control Unit. Renée Battle Brooks is the executive director of the Prince George's County Office of Human Rights. Before that, Renée served as a Maryland assistant public defender and assistant state's attorney for Prince George's County. Jose Villegas is the assistant director and the manager of the investigation division for the Prince George's County Office of Human Rights. Jose has worked for Prince George's County government investigating violations of anti-discrimination laws in the areas, including employment, for 19 years. Pamela Ashby is of counsel with the law firm of Jackson Associates in Upper Marlboro, Maryland. And Pam represents management in employment disputes. Jay Stafford is the founding member of the law firm of J.W. Stafford in Columbia, Maryland. Jay represents employees in employment disputes. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Jay Stafford on the Prince George's County Office of Human Rights and the Prince George's County Rights Ordinance in practice. Jay, start us off.
Hey, thanks, Scott. Good afternoon, everyone. Today, we're going to explore the vital roles and functions of the Prince George's County Office of Human Rights and the Human Rights Commission. Understanding these entities is important for anyone working or handling a matter in the county. As an initial matter, it's important to point out that the Office of Human Rights and the Human Rights Commission are two separate entities. The Office of Human Rights is the investigation and enforcement arm for the anti-discrimination laws within Prince George's County. The Human Rights Commission is an independent adjudicatory body. It consists of 13 members appointed by the Prince George's County Executive and confirmed by County Council. Next slide, please. All right, so let's begin by delving into the Office of Human Rights. This office plays a pivotal role in enforcing anti-discrimination laws across Prince George's County. These laws cover various sectors, including employment, which includes ban-the-box legislation in effect in Prince George's County, residential and commercial real estate, and public accommodations. The Office of Human Rights has a work-sharing agreement with the U.S. Equal Employment Opportunity Commission, which allows them to investigate discrimination complaints under federal statutes, such as Title VII and the ADA. and ADA. In terms of the local laws that guide the work being done by the Office of Human Rights, Scott mentioned that is found in the Prince George's County ordinances. The anti-discrimination provisions in the county's ordinances are applicable to employers with one or more employees, as well as Prince George's County government. The anti-discrimination provisions in the county ordinances are meant to be substantially similar, but not necessarily identical to the discrimination prohibitions found in federal and state law. Next slide, please. All right, now let's look at the enforcement process. This is where we see the practical application of the laws. From filing complaints to investigation timelines, understanding the process is key. To start a complainant, generally speaking, has to fill out a form and then get scheduled for appointment with an investigator. It does look like attorneys can cross-file their charge of discrimination with the Office of Human Rights. In terms of filing the charge of discrimination under the county's anti-discrimination ordinances, a charge generally has to be filed within 180 days after the alleged discriminatory act, except there is a 2-year time limit for allegations of harassment. As it relates to the investigation process for housing discrimination cases, the Office of Human Rights generally has to reach final administrative disposition of the complaint within 1 year of receipt of the complaint, or provide in writing the reason for the delay. If after investigation, the executive director believes no violation has occurred, she can dismiss the charge, and an adversely impacted complainant can appeal the dismissal to the commission within 15 days. The complainant does have the right to bring an action in the circuit court for Prince George's County, so long as he or she files suit within 2 years after occurrence of the alleged discriminatory act. That timeline is found in Maryland Code Annotated State Government Article Section 20-1202. To exhaust administrative remedies under the county ordinance, you have to have your complaint on file with the Office of Human Rights for at least 45 days. The exception to this 45-day exhaustion requirement is when you have an allegation of discrimination related to real estate. In that case, it appears that suit can be commenced at any time. Next slide, please. All right. In cases where violations are found, the conciliation process begins. This stage involves negotiation and agreement, aiming to resolve issues effectively. If the executive director believes a violation has occurred, she must attempt to conciliate the matter within 20 days after the determination has been made. If the parties agree to the terms of the conciliation, the terms of the resolution are memorialized in a written consent agreement, but there's no admission of violation of any law. A written consent agreement must be approved by a majority vote of the full body of the commissioners, and they retain jurisdiction to enforce the agreement. Next slide, please. Finally, we're going to review some of the key case law. These legal precedents provide insight into how the anti-discrimination laws have been interpreted and applied in Prince George's County. Understanding these cases is crucial for anyone bringing suit under the statute. The first law is the statute I previously mentioned that sets forth the time limit to file a civil action in Prince George's County Circuit Court. That's Maryland Code Annotated Section 20-1202. Again, that section also, excuse me, 1 second. Yes, so if you're looking at that, that is the key statute you must reference, again, in order to timely bring your claim in circuit court for Prince George's County. Again, you have the 2-year time limit to file suit. Again, you have to exhaust administratively for at least 45 days. The next case we need to look at is Ruffin Hotel v. Gasper. That's a key case which held that under Maryland law, a plaintiff must provide must prove retaliation was a motivating factor in her termination, but not a but-for cause. We've included the Maryland civil pattern jury instruction that lays out what is required to prove intentional discrimination. You'll notice in the pattern jury instruction, it makes clear that a motivating factor is a factor that made a difference in the employer's adverse employment decision. It does not have to be the sole or exclusive reason for the employer's decision. So that's very important there. Next slide, please. Another important case is Edgewood Management v. Jackson. This case held that civil actions filed under county ordinances are not subject to the damages caps. The rationale being that civil actions initiated under state government article section 20-1202 makes no mention of damage caps. So the common law, Maryland's common law on damages would govern. Punitive damages are available if a civil action is filed, so long as a nominal amount of compensatory damages are awarded. Punitive damages, as the case outlines, requires a showing of actual malice. Hannah v. Emergency Med Associates explains that actual malice is the performance of an unlawful act intentionally or wantonly without legal justification or excuse, but with an evil or rancorous motive influenced by hate, the purpose being to deliberately and willfully injure the plaintiff. Another option for a complainant is that they can proceed with an administrative proceeding before the commission. So if you don't want to file civil suit, the complainant can go before the commission. If, however, the complainant decides to pursue an administrative proceeding with the county's Human Rights Commission, there are caps that would apply. In Prince George's County, the Human Rights Commission has a cap, a cap of $200,000 for humiliation and embarrassment. So there is a cap there. Again, if you file civilly with the circuit court, no damage caps applies, but if you decide to go through the commission, there are caps. Hopefully that was helpful and sets the stage for us moving forward. So thank you.
Jay, thank you. And let's begin the Q&A portion of our program with some questions about the Prince George's County Office of Human Rights. Renee, thank you for being here. We are grateful for you being here. I understand the Prince George's County Office of Civil Rights just celebrated its 51st anniversary. Take us on a tour of your office. How's it structured?
Perfect. Thank you, Scott. Yes, soon it'll be 52 years. I believe June was when the law took place in 1972. We came about really as a result of Teresa Douglas Banks, who was a citizen of Prince George's County, a wife, a mother, an educator, and she looked around and saw things that disturbed her greatly and decided to lobby and push hard for the county council to pass this law. It's actually at the same time that Prince George's County moved to its current form of governance with a county executive and county council away from the commission system, I believe, that Charles and perhaps Calvert County still uses. And so our law was the first law that was passed under this new form. So our office has 4 divisions. We started off with Teresa Douglas Banks' push for this agency as investigators of discrimination. So you heard in the opening what we have authority to investigate. We like to say where you work, live, or play, so it encompasses the 5 different areas. So that's our first division. And Jose Villegas, who is here with us, is the Assistant Director of the Prince George's County Office of Human Rights. And he's also, as you heard, the division manager. So he'll speak more to that because he's the expert in that realm. Our second division is human trafficking. In 2013, County Council recognized that human trafficking, in fact, does exist everywhere, as well as Prince George's County. And so they stood up the task force. So we are tasked with providing the coordinated collaborative response to both labor and sex trafficking here in the county. And by legislation, I chair that task force. Our third division is language access. That was passed in 2017. Language access, it's about an 18-page legislation, but really boiled down to its simplest terms. It says that everyone seeking county government services, they are entitled to those services in the language of their preference. So it's a mighty task, but we're up to it. And our fourth division is our public outreach and engagement, because we are the county's civil and human rights education and enforcement agency. We try to really engage and educate the public on all things civil and human rights, because we're trying to reduce instances of hate, bias, and violence. And ultimately, although Jose doesn't like me to say this, work ourselves out of a job, right? So if we can reduce all of those things that cause people to come into the door in our investigative unit, then we have done our job. So that's just a brief overview of what we do and who we are. Thank you.
Tell us just the distinction between your office and the Prince George's County Human Rights Commission. Just explain that to us so we get a sense of where that dividing line is.
We are part of, it is all the Office of Human Rights, but it's confusing, right? So the Human Rights Commission, they are the quasi or the adjudicative body of the Office of Human Rights. So the HRC, Human Rights Commission, are the 13 citizens that are appointed by the county executive that are given the authority to hear cases that we bring to them if we're not able to successfully conciliate. So they are the hearing authority. They are also the body that if a complainant or a respondent doesn't like the, I guess really complainant, doesn't like the determination that has been made, they can appeal to that body. They're the body where we seek subpoenas if we need. They are the body that really serves as that overall adjudicative body. Jose, did I leave anything out?
No, you didn't.
Renee, thank you. Jose, let's bring you into the conversation. How many investigators total does your office have?
Good afternoon. The office, the Division of Investigation currently has 6 investigators.
Step us through the intake process so that the individual comes in and files a complaint with your office. Step us through that process.
Yes, what happened is, somebody wants to file a discrimination complaint with our office. They call, we schedule an appointment. Right now we're doing mostly virtual because I think one of the things that we find out through COVID is that sometimes it's easier for whoever wants to file a complaint to either do it by phone or do it by other virtual media, virtual platforms. And so when we have this intake interview, we ask the person who wants to file a claim how they were discriminated after we conduct the interview and we hear all the narrative. Then if we take a complaint, we draft a charge, we provide the charge to the person, and is reviewed. After the charge is signed, then we forward the charge to the company with a list of list of evidence requests, position statement requests that we ask them to provide us. And so that is kind of what happened in the intake process. Interview, and then after we take the complaint and we notify the company and request information from them.
Let's take a scenario where the complainant is coming to you right before the regulatory deadline, the statute of limitations, which all too often happens. The date on which they come to you, is that the date on which the statute is told, or is it when you later prepare the charge of discrimination? From your perspective, how's that working? What's happening there?
Yes. So what usually happens if we have somebody say, my statute of limitation or the time to file into next week, and if we don't have a an appointment at that time, what we usually tell the person is to send us an email with a narrative of the allegations to our email address, that is OHR staff at copg.md.us. And we use that email in the narrative after we to hold the date in a way. So when we have the interview meeting, and then we obtain additional information from that person, we use the date that the email was sent as in the charge in order to kind of preserve that time, the time to file. That is, again, if it's close to file. Now, if the person if the statute of limitation already happened, then we usually still schedule an appointment, because I think it's for the office. I think it's fair to provide that time to the person who wished to file to have the meeting with them, and then at that point we either tell them, depending on what time they're filing, whether there's something that they can approach EEOC or another agency. But that's what we usually do in order to preserve that time or the date.
Now, once you have drafted the charge and you're proceeding, do you provide a copy of that charge to the employer?
Yes. So when we draft the charges and the charging party of the complainant signed the charge, then we notify the employer. We provide them a notice of a complaint of discrimination. We provide them a copy of the charge, and then we provide them a document listing some of the documents that we want them to provide, and we give the employer a time frame or deadline to submit that information. And that includes, the position statement, in other evidence to support their position.
And once the employer submits their position statement back to you, under what circumstances do you share the employer's position statement with the complainant or complainant's counsel?
Per ordinance or per our ordinance, Division 12, we do not share the information between, if we get some information from the charging party, we do not share it with the company besides the charge. And that is the same thing if respondent provides us information, we do not share it with the charging party. The only time that we can share the information is, and also is listed in under the code, is that if both parties agree. So CP might ask the request to us, can I share it? And we will say no, but you can ask the respondent if they are willing to share that information with you, or we can serve as a conduit for that. Like, he can send us an email, we forward it to the respondent attorney, and then the respondent attorney will let us know whether we can share certain information or not. But we, as a practice, do not share the information because that's part of that requirement of the ordinance.
The company, let's just say, has responded. They've submitted their position statement to you, and you've got some questions about the position statement. How often do companies voluntarily make available their human resources representative or company representative to answer your investigators' questions about the response?
Well, it is probably maybe less than 1% that decide not to comply with our requests. I mean, one of the things that we have is the peanut power. But usually if we request to interview the HR, if the human resources, if anybody from that department is involved in the decision process of either disciplinary action, termination, and while we reviewing the information that is provided, we determine that that person is necessary in our investigation, and we want to interview, the attorney comply with the request. sometimes what happened is the attorney might not provide a lot of information on when they supposed to provide us with a response, because it's a belief that less is best, especially complying to an agency that investigate discrimination complaints. But they usually at least 99% of the time they comply with our request of providing a member.
Let's take our first question from our audience. We have a question here from Tom Gagliardo. What's the role of the attorney representing the complainant? How can the lawyer representing the complainant assist in your process?
I think in the process, especially when the person comes to us, the role of the attorney for the CP is very minimum in our office, because we do the investigation. We already have a charge or discrimination, so we know what the information. Sometimes the attorney, especially in CPs, the attorney that's representing CPs, make it a little bit challenge for us, because they either want to not sometimes allow us to do a follow-up interview with their client, or they're trying to control the narrative from their client, even though we need the direct information from the client. So one way that they could potentially help is just, if they do have the information from the client about witnesses, they can provide that. But in the process, it's very minimal with us.
Renee, let's turn to you.
Yeah, that's a really good question, because as we go through our process, really our role, we're the neutral body. We don't want to be swayed one way or the other. We want to follow the evidence, as simple as that. Where does the evidence lead? And so I can say that sometimes when a complaining person, and Jose says CP, that's what it means, the complaining person, has an attorney, that's great. We don't discourage that. But when it comes to the public hearing, if we find cause and if conciliation attempts are not successful, then the next stage is certification for public hearing, and it goes to the commissioners, the Human Rights Commission. And the attorney there has no role, because it's the executive director's case versus the respondent. And the commission, does not award attorneys fees if they're there, and right? So they're merely a audience participant during the hearing. And so it's a little bit, it's just something to know, because, sometimes when there are attorneys involved and they're asking for attorney's fees, the commission does not give attorney's fees. So I think that's just something important to know.
Let's take our second question. Renee, I'm going to pose this to you.
Mm-hmm.
Can you share any statistics about the number of complaints filed on average, and how many of those complaints are pending investigation or resolution at any given time?
So I'll start the question, and then Jose is the numbers guy. So at any given time, right, we have complaining persons that walk in the door. We have transfer cases from EEOC. So it all works at the same time. So it's ever evolving and revolving. So Jose, you can, if you have those stats.
Well, most of the complaints that we take, especially in employment discrimination, it's fall under the Title VII. Any of those protected classes that deal with race, sex, national origin. We do take some, but it's not as much of the disability. Now, one of the things that we have noticed is the pattern that usually, that people file complaint of discrimination based on certain protected classes like race, sex, national origin, religion, and we might not find sufficient evidence to support the claim, but those claims also include the retaliation piece. And then most of the cases sometimes that we found cause is because not necessarily the main issue that is the race, sex, national or discrimination, but that after action that respondents take or company takes. And so we find that on the retaliation piece. Now, in terms of the numbers of cases that we have, like Ms. Brooks mentioned, is kind of revolving door is because we complete the investigation of cases, but we still have cases coming in. So in average, if I were to provide a number, would be that we have leads between 80 and 90 cases in a span, that we have actively working, and that is cases that we can that we have closed, cases that are coming in at the same time. So it's for just to throw kind of a number, but it depends, because sometimes we take cases ourselves in office, and sometimes EEOC transfer cases to us based on the work sharing agreement. So it's a high kind of number that we close, we have open cases, so it's never ending.
Jose, thank you. I want to turn to the Prince George's County Circuit Court now, and Judge Killough, I'd like to bring you into our conversation. Give us a sense of the status of the post-COVID court jury trial backlog. I know there was significant backlog after Maryland courts closed, beginning in May of 2022. But what's that backlog looking like now?
Well, thank you, Scott. I think before I answer that question, though, I would be remiss if I didn't mention the fact that a lion of the Prince George's County legal community, appellate court judge Jim Salmon, passed away yesterday. I'm sure you'll all join me in sending my thoughts and prayers to Judge Salmon's family. Now, as to the backlog, I'm happy to report that there is no more backlog. I think we're back to business. Again, I want to thank all the judges on our bench and our staff and all of you for being patient as we work through that backlog. It was a pretty difficult process, but I'm happy to report that we're all caught up.
Terrific. So just step us through the process of how a case kind of is assigned at the outset if filed in the Prince George's County Circuit Court. I know that some are specially assigned, but most are not. Give us a sense of how that works.
All right. Well, I think you're talking about track 3 cases. Those are the typically the B&T cases and the MWELA cases. Those are specially assigned. Those will go to, in this case, Judge Snoddy, who is our coordinating judge for civil, for a scheduling conference. If he believes the case is going to go forward, or he believes this actually is a track 3 case, then he'll go to calendar management, find out who's the list of judges are available, and Judge Cotton will select who the judge will be on for those special assigned cases. Now, for non-track 3 cases, including employment cases, those are assigned to whoever the judges are on the civil, who are assigned in the civil division, and they'll be assigned the cases from case numbers ending in 0 to 9. If the case ends in a 0, for example, it'll go to one judge. If the case number ends in a 6, it'll go to another judge. That's typically how the cases are assigned.
Judge Killough, thank you. Jay, let's turn to the ordinance just for a moment. You talked a little bit about the standard for causation. It's a motivating factor standard. Does it encourage you to bring a claim under the ordinance rather than, let's say, under a federal statute that might have a but-for standard of causation?
Yeah, absolutely, Scott. The great thing about the ordinance is, like you said, it does have motivating factor causation standard, and that's one less hurdle as a plaintiff's lawyer. You've got to, it makes it a little easier to kind of get the case to conclusion. And so, I absolutely would encourages me to bring a claim under the ordinance. Look, the ordinance, bringing a claim under the ordinance with no damage caps in the circuit court. That's absolutely another good reason to bring a claim under the ordinance for sure.
Jay, thank you. Pam, let's turn to you for a moment. Talk to us about the challenges for you as management counsel when an employee files a claim under the Prince George's County Human Rights Ordinance versus, let's say, a claim under the ADA or the ADEA or other federal statutes?
Sure. Good afternoon. I think based on in his overview, Jay really kind of hit on that when he talked about the cases that really weigh more favorably when you read the rulings for an employee. And I think specifically, Scott, that includes, Jay mentioned Edgewood. Edgewood Management Corporation versus Jackson is a case where an employer filed a claim of retaliation. And following trial, the jury awarded plaintiff $500,000 in economic damages and $150,000 in non-economic damages. And the employer appealed that case. And the Appellate Court of Maryland made it very clear that unlike the federal statutes, there was no damages cap there was no damages cap. And so that jury award was upheld. And oftentimes I think employers thinking that the same standard applies as it does under the Title VII, for example, where the number of employees may drive an award. And so that's significant. Jay also mentioned Ruffin, and Ruffin Hotel Corporation of Maryland versus Gasper is, in that case, the Supreme Court of Maryland ruled that, the but-for standard did not apply in the retaliation claims. And as I think we would all agree, it is a less difficult standard to meet. So, and then there's also the case regarding the burden of proof that I think it's important relative to comparators. So if you have a disparate treatment case, there's the case of Taylor versus Giant of Maryland. And in that case, we have the situation where the comparator standard, the court said you don't just, this isn't cloning. You don't have to have a clone. You can, it can be fact specific. And so they're looking to see that it may be more than the two had the same supervisor. And so it's really important that employer counsel take all of that in consideration, that these are key factors that weigh into an employee's potential success in pursuing a claim under the ordinance in state court.
And thank you. Renee, I want to turn to you, back to how things are working with your office. Does your office mediate disputes?
Thank you. Great question. Yes, we do. We encourage mediation, in fact, at all levels throughout the investigation. And of course, as you know, mediation requires that both parties consent, versus conciliation after a finding is regulated by the local law, does not require consent. It's mandatory.
And you mentioned conciliation. We have a question here from Kristen Sinisi. With respect to conciliation, I understand that the executive director may dismiss a complaint if the complainant does not accept a settlement offer by the respondent, which in the judgment of the executive director is a reasonable good faith offer. What standards are you using to determine whether a settlement offer is a reasonable good faith offer?
Yeah, good question. So, and I'll say that we usually err on the side of not dismissing, but if there's something that is so, based on the facts of the case, and there has been, as I said, good faith from the respondent to look at it. We look at what other settlements are. They're different things, but it's case by case. I don't think we have dismissed one since I've been here, and this is my 5th year, but it is a tool because not everybody comes with clean hands, I should say, right? The administrative process is not a cash cow. It's not a place to, it's not a place, to get that $1 million settlement because your coffee was too hot, just as an example. So I don't know if I've answered the question, but it's something that we look at. Yeah.
The conciliation that you undergo, does that occur only if there is a cause determination? Is that the predicate for that?
That is correct.
Explain that, if you will.
Yeah, that is what Division 12 says. So if a cause finding is made before we go to public hearing, we must attempt to conciliate the matter.
And Jose, talk to us about the when you are making a determination about whether to recommend cause to the executive director. How does that process work with the investigators and you?
Yes, so as I mentioned earlier, we have 6 investigators. Everybody has their own caseload. Again, going back from the beginning, after they get the information from the company, from the attorney, they review it, they determine whether they need additional documents or additional evidence. They determine who they need to interview based on that complainant's allegation, and based on whoever took actions from the respondent side. And so after all of that, it's done, reviewing of the documents, interviewing witnesses from either side, independent witnesses. Sometimes we do have independent witnesses, especially for sexual harassment claims, people that used to work in the past, and then sometimes we get their number, we interview them. Then the investigator has to put all the information together in a recommendation. So the initial review, after the recommendation goes to me as the division manager, and then after I review the recommendation and some of the evidence that were collected, if I agree with that investigator, then we work a little bit to fine tune it, then we send it to the director for her review. Now, if after their submission I still have questions, then that's when the investigator and I meet to discuss it and see whether we need to seek additional information from either party. And then after that is done, then again, either the cause or no cause finding goes to the director for her final review and determination.
Thank you. Taking another question from our audience. Complaining parties typically must attest to the truth of their charge of discrimination under penalties of perjury. Does the Prince George's County OHR require employers to attest to the truth of their position statements under penalties of perjury? Jose?
We don't, when we take a complaint, we do not ask the charging party to get it notarized, nothing like that. Sometimes we do, sometimes I don't think it's necessarily based on our ordinance. And again, it's somebody is just alleging something, so they have the right to file a claim if they believe that they were subjected to discrimination, and that's the same thing. So we don't ask we don't ask the CP, we don't ask the respondent. Now, if the case goes to public hearing, at the point, then the commission does conduct an oath. They swear in the witnesses and CP and representative of the company, but not in the administrative process of investigation.
Jose, thank you. Renee, back to you. Let's assume for the moment conciliation has been unsuccessful and you decide to file the charge with the commission. What happens next?
So I file a motion to certify with the commission. Commissioners meet for commission meetings the last Monday or the fourth Monday of every month. So they would meet in closed session because, as Jose has said before, everything that we do is confidential. We are prohibited from disclosing anything to anyone, even, the parties, other things, until it goes to a public hearing. So they meet in their closed session to certify it. It then comes back. They select a panel to hear, and a panel chair consists of 3 and an alternate. They then provide a scheduling order, and the clerk to the commission then is the conduit between respondent and executive director's case. And really everything is out of our hands once we send it to the Human Rights Commission.
And just
They then schedule the dates, and hearings are in the evenings typically. Yeah.
And just to give folks a sense here, how many of these certifications has the commission made, let's say, over the last couple of years?
Jose, I don't know, 2 years, maybe certified cases sent, because we've had cases certified, but then they settle before we can, right? So I'd say, I don't know, 16, I don't know, in a 2-year period.
Thank you.
But I don't know, Jose would have.
I just want to add that I was looking at that information early before this program, and it's been 9 cases that have gone to public hearing. Now, this is the period of 2 years. But again, as Ms. Butterbrooks mentioned, some of the cases don't reach that level because it's settled in conciliation. So that's only cases that actually have gone through the process.
And I'll say that during COVID, we suspended, because we were in person before COVID, always in person. We suspended for the first year, a year and a half, I think. And then we started, so we had a backlog. So we certified quite a few in that first or second year of COVID. And then we've certified a lot more. But again, a lot of those settled before they came to public hearing, but after conciliation was not successful.
Thank you. Jay, let's talk about the advantages of prosecuting your client's claim administratively before the OHR and the commission rather than in court. Give us a peek behind the curtain in terms of your decision making.
Yeah, so I mean, look, in terms of pursuing it administratively, I think that the advantage is that you potentially could get a resolution sooner for the client. Obviously, and as Judge Killough mentioned, I think Prince George's County has, worked through the backlog, which is great, but you still, to go take a case through discovery in circuit court, hearings, motions, you're going to take a little while. Administratively, I think you're going to get to a resolution sooner, perhaps. And so that is an advantage. As Ms. Battlebrooks mentioned, the executive director, I guess there's really not much for attorney to do in the administrative side, but, they take the case and hopefully your client can get to a resolution sooner. And so that's, I think, a big benefit of pursuing administratively.
Pam, if the Prince George's County Office of Human Rights asks for your consent to interview your company's employees, when do you consent?
Certainly, again, it's always going to be fact-based, but I think it would not be, we're more likely to consent if the position and what we can present is strong and definitive and clear. It's the muddy cases of which I've been on the other side, when you have a workplace where the people they potentially will interview will open so many Pandora's boxes that you absolutely want to run the other way, where you're going to be nervous about opening up the doors to let an investigator come in and perhaps see a workplace that is, right with a lot of employment issues. So certainly, if the employer is large enough to have a human resources representative or someone, you want to give them the opportunity to speak to that person and support your position that you did not do anything unlawful.
Under what circumstances will you agree to mediation before the Prince George's County Office of Civil Rights?
Certainly in a case where we have a strong defense, where the employer has taken good documentation and can clearly establish, and no case is guaranteed, because you can believe you have a very strong case and get before a jury and they send you home with your tail between your legs. But certainly in a case where the documentation is strong and definitive, I think it would be reasonable, to go to media to participate, but not with the sense that you're going to have to open up your purse, but certainly you want to try to get the thing resolved as quickly as possible.
Thank you. Jose, back to you. Let's just talk about the office's jurisdiction for a moment. Does an employer need to employ any particular number of employees to be covered by the Prince George's County Human Rights Act?
According to the act, if the employer has one person, we have jurisdiction.
If the, let's just say the charge comes in from an employee who is located in another state and works remotely for a company that's headquartered in Prince George's County, will your office investigate the charge?
I think it's all depend on the I think it depends on what's being alleged, because I think even with conversation with our partner, the United States Equal Employment Opportunity Commission, the idea is that if the person is working in Prince George's County and that company is headquartered somewhere else, then we would take it, right? Because the person is working in Prince George's County. Now, if the person is working in Virginia, but the company is here, then I think one of the first things that needs to be searched is, well, I think more than likely the person needs to file with a Virginia agency, because the person is working there in there. But it depends on, I guess, some information, additional information. But I would say that the first thing would be, if the person is in Virginia, file with Virginia. I think EEOC has established also that it's where the person is located. You can file the claim even though the company's headquarters is somewhere else. So I would say that that's what I would suggest.
Okay, let's turn back to Prince George's County Circuit Court for a moment. And Jay, talk to us about the advantages from your vantage point of using Government Code 20-1202 and its uncapped damages rather than, for instance, Title VII, the ADA, that have caps on damages. How does that change the calculus of when you're going to court?
Yeah, well, as Pamela mentioned, I think not having the caps could potentially change the calculus on it on the employer side. I think it's depending on the case. Not having a cap situation for an employer could be a very precarious position, and so this huge advantage of of filing suit under that statute and not having a cap, and it could potentially put the client, my client, the plaintiff, in a great position to potentially get an early resolution, because again, with no caps, it could potentially change the calculus on the other side for sure.
Pam, how often are you seeing employees pursuing their employment discrimination cases in Prince George's County Circuit Court using Government Code 20-1202 rather than, for instance, filing under another federal statute in federal district court?
Surprisingly, it's not as frequently for as I would like to believe that it should be based on those circumstances. And I think that's unfortunately just based on the unfamiliarity with the benefits of pursuing a claim under the local statute versus the federal statute, which more people are aware of.
Sometimes employees include other kinds of common law claims, Pam. And if an employee chooses, let's say, to include an intentional infliction of emotional distress claim with their discrimination claims, any risks at all associated with that?
I mean, certainly, absolutely. It's a high burden to me to meet in terms of proving intentional infliction of emotional distress. And certainly in that situation, an employer, could take advantage of pursuing obtaining a medical, a Rule 35 medical examination to really kind of open the box and identify other reasons for the emotional distress that an employee is claiming. But more generally, in addition to intentional infliction of emotional distress, you have breach of contract, you have other causes of action which create more exposure. So, you could very simply be in a situation where someone, perhaps their discrimination case isn't as strong. Maybe they have a decent retaliation claim, but they have a great breach of contract claim. So you have to take that into consideration in factoring in how you should proceed in defending a case.
Jay, what makes Prince George's County Circuit Court a good place to prosecute an employment case?
First, you got a great bench in Prince George's County, no question about it. But second, Prince George's County, look, you've got a really diverse county, and that is a good thing for a plaintiff's lawyer. And you've got folks there who work federal government, private sector, and certainly have, there's, the incomes in Prince George's County are fairly high. And so you are potentially, dealing with a jury pool who may not be scared of a big number if you ask for it. So I think there's a lot of good reasons to pursue a claim in Prince George's County Circuit Court. Sure.
Let's turn to drafting that complaint that's going to be the introductory document, Jay. When you are drafting a complaint for your client and you are thinking about whether to include an individual defendant along with a corporate employer, talk to us about that thought process.
Yeah, I think the thought process is, that individual defendant is he or she a bad actor, and do we want him or her at the table? Somebody who the jury or fact finder can look at and we can put a face to the sort of the bad actor. And so I think that's a consideration I have when thinking about whether to name an individual defendant.
Pam, does naming an individual defendant promote or hinder settlement of an employment discrimination suit?
It could be both. The answer could be both. I think, in a situation where you have, as Jay said, a bad actor, even if they get separate counsel, you want to, and you separate yourselves to the extent that a jury is going to attribute that bad actor's behavior to blame you, employer. You want to try to settle it and not have someone else decide for you. You want to separate yourself from that individual, but you also want to consider settling, because as the deeper pocket, the jury may penalize you for that bad actor. So it's really about trying to protect yourself and your client.
Thank you. Judge Killough, I'd like to turn back to you and talk a little bit about motions practice and in particular, dispositive motions, summary judgment, for example, what do you wish you saw more lawyers do or present in their motions, their dispositive motions that they're filing with you and their oppositions?
Well, that's a pretty hard question. I mean, I think most important thing, at least for me, is lawyers having an honest assessment of their arguments. I think nothing really annoys me more than lawyers ignoring or giving short shrift to facts or case law that doesn't support their position. I mean, I call it the sort of head of the sand or the ostrich. I mean, they don't really address it in their motion, and they're sort of somewhat surprised if it gets denied. I learned, seems like 1,000 years ago when I was an associate in a law firm in New York, that, I mean, it was beat into me never to ignore bad facts or bad law. You can distinguish the law, you can distinguish the facts. I think as a judge, I learned to appreciate that more. I mean, obviously, I have a law clerk that looks at the cases as well. So it's going to be difficult to sort of pull a fast one, I think. And, you have two sets of eyes looking at the case. You have the opposing counsel looking at the case, and you have judge's law clerk or the judge's herself looking at the law. And so I think you should just be set forth your case, make sure, cite the cases or facts that support your position, cite what the opposition states, file a reply brief. Sometimes you don't get reply briefs, which is surprising to me. File a reply brief, and respond to the arguments made by opposing counsel. And I would like to see more of that, especially on a motion to dismiss. I mean, sometimes it's best not to make a motion to dismiss for failure to state a claim when, that's just obviously the lawyer stated a claim. I mean, I think the it goes along with your reputation as a lawyer. Judges certainly are aware of that, and I don't really like. I wouldn't call it frivolous, but I wouldn't like motions that I think have a very, very extremely low chance of prevailing. If you have a good motion for summary judgment, save up the case for a motion for summary judgment. I think judges on our court, at least I'm willing to grant a motion for summary judgment if I have a good one. Sometimes less is more if you have a case on point or if you have some facts. You don't want to bog down your argument for or against summary judgment with a lot of extraneous things that you may or may not win on. I mean, I think just throwing everything against the wall and see what sticks is not a real fruitful way to approach motion practice. Go with the arguments you think are the best, maybe go at your second best, and then leave it at that. But again, you have 24 judges on the bench, you have 24 different opinions, but that's my view of the issue.
When do you take the extra time to write an opinion at the summary judgment stage instead of simply entering an order?
I think, Scott, that's fairly rare to write an opinion. I mean, I don't, at least my practice is, I think I started off trying to write opinions, and just with the volume of cases are such that I don't want to waste people's time. It's not like, I'm not a federal court judge where, you have two or three law clerks, and you don't really really have that many trials, and you can sit and you can take 9 months to write an opinion. I think it's important to get, have the salient facts out there, have the salient facts that support your position. I'll give my opinion verbally. If I'm not sure the first day after the hearing, I will set a disposition date after argument, and I'll lay out my reasons why I'm ruling for or against summary judgment. But it's pretty rare that I'll write an opinion.
How often do you grant summary judgment without having a hearing?
That's not infrequent. sometimes you have lawyers who don't deny. I mean, first of all, you don't get opposition. You really don't get valid, reasonable oppositions. You get oppositions that either ignore the issue or they don't even file one. So I would say in those cases, pretty high. In cases where there is a vigorous opposition and there's affidavits attached to it asserting genuine issues and material fact, I'll probably have a hearing on those cases. And after the hearing, if I still find that there's a genuine issue material fact, I'll probably deny it. If not, then I've been known to grant summary judgment.
Jay, back to you for a moment. Do you find that summary judgment is less frequently granted in Prince George's County Circuit Court versus federal court? What are your thoughts?
Yeah, I mean, the exposure I've had there to Prince George's County, I found that it is a little bit less frequently. But again, if you think federal court, like Judge Killough said, they're I think more inclined, shall we say, to grant summary judgment than the other courts. So I think it's certainly less likely to get summary judgment, get kicked out on summary judgment in circuit court.
Judge Killough, let's turn back to you for a moment. Pre-trial motions, let's say that summary judgment has been denied, the case is going to trial. How can lawyers best present those pre-trial motions to you?
So it depends on whether the case again is whether it's specially assigned. Obviously, if it's special assigned, the earlier you get the pre-trial motions to the court, the better. Especially if it's involving experts, if there's any in limine motions associated with that, I think the sooner you get it to me, the better. If the case is a special assignment, unfortunately, I think many employment cases are not. You get the luck of the draw. It depends on who the judge is. I think we are instructed as a general rule, again, 24 different judges, 24 different opinions, but we are instructed, and I try to do that. I try to rule on pre-trial motions, even if I'm not the judge, even if I won't be the presiding judge. Some judges take the view that it should be reserved for the sitting judge. My view is that if it's in my queue and it's teed up, that both parties have looked at the case. Have responded to the motion. If it's right, then I should rule on it. And it becomes, I don't say it's law of the case necessarily, but obviously, I guess it'd come back from me for reconsideration, I suppose. But it depends on, again, even if I'm not the judge who the case was assigned to me for trial, and I didn't do any of the pre-trial motions. Also, that has a tendency to slow things down. I've had cases where there's a bunch of motions that haven't been ruled on that were filed before trial, and I will have to, after we select a jury, I'll have to spend the day resolving those motions. I probably will send the jury home after voir dire, and then resolve those motions and then have them come back the next day. But I'm sure most of the lawyers here experiences are different, depending on the judge, but I try to get to all the pretrial motions because I think I think that's part of the process. That was partially why we were able to resolve, I think, our backlog is to resolve those outstanding motions.
Let's move to trial of an employment case. Pam, starting with you, what are the themes that you are consistently using at trial in the defense of an employment discrimination case?
I think probably some of the key themes that I would use representing an employer is the effort that we have a fair workplace. And that because the work and the employment at will doctrine, just in terms of, we have a right to make a decision. It's not motivated by it. We had a fair workplace and we have policies that govern workplace conduct. We followed those. And this employee did not take ownership of his or her bad behavior. And so, we certainly want to ensure that that whole issue of personal responsibility is something that we continue to hit upon and emphasize, and that works beautifully, with the exception of those cases where you just have a super awful employer who's not going to be who's very unlikable. But aside from those type of situations, those are the things. And personal responsibility, it's a fair workplace, and the employment at will doctrine. And read the facts into that framework.
And thank you. Judge Killough, talk to us about opening statement for a minute. What's the one piece of advice that you would give to a practitioner preparing for opening statement?
I would say have a theory, have a plan. Tell them what you expect the evidence to show. Don't bore the jurors. So keep it relatively succinct, but understand that it's to be held to account during closing if you haven't proven the points you make an opening. You haven't proven that in your case in chief. But just have a theory of the case. You can tell a story. I think those are typically the best, as long as you have the facts to support it, and that you can, when you close, you can tell the jury that I promised you this is the story, and this is why we demonstrated that in the case.
Thank you. Jay, there are lots of different opinions about witness order in your case in chief when you are prosecuting an employment discrimination case. What witness order do you mostly use?
Yeah, I think certainly the client goes last. You want your client to hear what everything that's been said, and hopefully keep everyone in sort of an anticipation of what what he or she may have to say. I think that is sort of one of the things that I sort of focus on. The earlier folks, that is sort of flexible, but I usually like to do my client last to give him or her the opportunity to address again everything that they've heard come out, and to really just sort of be the final, at least the key witness. So I like to have them at the end.
Thank you, Judge Killough. Let's talk about demonstrative exhibits for a moment. You've seen many uses of demonstrative exhibits in your tenure as a judge. What are some of the most powerful uses of demonstrative exhibits?
Opening statements using demonstrative evidence, and if it's a MWELA case, for example, to show the device, for example, if it's regarding the malpractice relating to an implant of a knee or a hip or something like that, to show what went wrong. I think that's very powerful. I think in employment cases, different charts could be used to show damage, especially in compensatory damage cases. I believe that they're very effective, as long as the parties don't sort of inundate the jury with them. They can be extremely effective.
Let's talk about evidentiary exhibits. Some lawyers like to publish after you've admitted the exhibit using a screen. Some might pass around the document to the jurors, publish it that way. Which do you think is the most effective?
I think by far on the screen. You'll have 8 jurors in a civil case looking at a document, and that takes away from the flow. That takes away the flow of the argument. We have to wait until all 8 jurors have looked at it. You don't want to ask questions when you have people looking at the documents that have been published. I think put it on the screen, ask the judge to publish it. They'll publish it, put it out on the screen, take a few seconds to let the jury see it, and you can leave it up on the screen. You can ask the next question. If the other side is savvy enough, they can ask the judge to take it down. But I think it's using the screen. Now, obviously, in the MWELA case, it's probably different. If, like I said, going back to the hip replacement or some kind of medical device that was, inserted wrongly, passing that around, or some, jurors get a chance to see that and hold it in their hands. I think that can be powerful. But in an employment context, I think publishing the document on the screen.
Objecting at trial, you have some thoughts on when and how often to object at trial. What are they?
I mean, that's really discretionary. I mean, not every, just because you can make an objection doesn't mean you probably should. I think jurors are the general proposition. They want the lawyer objects. And I instruct them, of course. I tell the jury that the lawyers are doing their job. They're only objecting because, and I give a long spiel about how the lawyers prepared the case and they only want you to have admissible evidence. But at the end of the day, jurors still wonder what the objection is about, why you're trying to hide information. I can't tell you the number of times I've gotten notes from a jury asking me asking a question about a ruling I might have made to keep evidence out or something of that sort. So, I think you should object if you feel it's really important for your case. But for the most part, especially in a civil case, I will probably err on the side of not objecting as much.
Let's talk about trying a discrimination case in general in Prince George's County Circuit Court. Judge Killough, jurors in some jurisdictions are skeptical about whether there is unlawful discrimination in the workplace. Jurors in other jurisdictions are more sensitive to discrimination in the workplace. Which way do jurors in Prince George's County lean in general?
Well, I think it was said earlier. I think they generally are open to the idea, but I think it's a more complex answer to that. I love Prince George's County jurors. I think that having tried cases in Baltimore and New York and around the country when I was in house at a corporation, our jurors are alert. They listen to the case. They're oftentimes underestimated, but they are so alert. They are so, they pay attention to nuanced things that maybe, as a judge sitting there thinking that, well, maybe I wonder if they get this or I wonder if they understand that. They do. Invariably, they almost always do. I think in general, our juries are very smart and will follow the evidence. I think they are probably a little bit more open as a general proposition in a civil rights case or a excessive force case, in terms of being more open, I guess, the one of giving a jury award in those cases. I think in employment cases, they pay a lot of attention. They don't have a problem finding discrimination if discrimination exists. I think, though, that when it comes to damages, that you have to show it.
Thank you. Let's turn to some of our questions here, and I'd like to begin with a question for Jose. Can you discuss the effect of cross-filing with the EEOC? What happens to the EEOC if your office does not find cause? What happens if you do find cause? What effect does either of these actions have on the individual's right to file, proceed to a lawsuit? Jose, you want to take that?
Yes. One of the things that, especially with duly filed cases, most of the people that are hearing this discussion are attorneys. They just get the opportunity either to decide to take it to court, either to file in federal court or a local, right? But what happens if a case is duly filed and we investigate it? If a case is duly filed and we investigate it, thus it's our case. EEOC take a case, it's their case. Now it is duly filed, is that when we investigate a case, then if we find no probable cause on case, then the charging party has one opportunity to appeal within the division or ask EEOC to conduct a substantial waiver review, right? So if EEOC conduct a substantial waiver review of our investigation, then if they agree with the findings, then EEOC will issue a right to sue. Now, if we find probable cause, then it has to go through the process in the county first. They have to go to either they go to conciliation, and if it's settled, it's fine. We submit that information to EEOC because at that point there's no substantial waiver review, so the case is closed. And if that's the same thing with if it's go to public hearing, then after the order is issued, we submit the information to EEOC, and because it's either a settlement order, then usually that our agency's determination or commission order is accepted. So, and one other thing that happened is that if you file with EEOC and you want to file with us, it's already cross-filed, we will not take another complaint. And I think that is the same thing with EEOC. If we take the complaint and you want to file the same case with EEOC, thinking that you could have same case a different agency, they will not take the complaints. If somehow they take the complaint and they become aware that we took a complaint, they will dismiss the second complaint. It's my understanding. So that is something that happens. But Ms. Butterbrooks, you want to add to it?
I just want to say, I think that also applies to our sister agency in the state, MCCR, the Maryland Commission on Civil Rights. So you have three options: us, EEOC, or Maryland State. But if you filed with one, the other won't, and we're prohibited by law.
Thank you. We are ready for final thoughts. Pam, start us off. Final thoughts.
Okay, final thoughts. So I think from the employer's standpoint, management side, I think it's really important that employers justify and support, with a legitimate business reason, the actions they take as related to their employees. And it just puts you in a better stead. Documentation. I don't think that can be stated enough. And take any employee claim seriously. I've seen situations where employers have essentially ignored the complaints and failed to address it, and that comes back to haunt them. And I think the last thought I would say is, from a management side standpoint, is to think before you act. I think human nature is just to react. I'm certainly guilty of that, but it has always done me well when I stopped and thought before I acted, and then I justified an action I've taken by connecting it to a legitimate business reason. And I think to the extent, I think as this presentation really underscores, I think everyone is really committed for the most part. There's always going to be that minority, but for the most part, everyone is committed to providing a decent, fair workplace for employees. So certainly from a management standpoint, if that is your mantra and you communicate with your employees, then you should be able to successfully defend an unwarranted complaint. And if for some reason there's that exception and it's not a good situation, then some management council may kill me for saying this, Scott, but I say own it, embrace it, and learn from it, and go from there. So thank you for allowing me to share on this panel.
And thank you. Jay, final thoughts.
Yeah, my final thoughts are, I think as plaintiffs lawyers, we need to be a lot more strategic about the form from the very beginning. I think as maybe someone on this panel mentioned, look, or actually Pamela mentioned that, she doesn't see plaintiffs' lawyers really taking advantage of a 20-1202. We, I think, as plaintiffs' lawyers need to get more intentional about taking advantage of this great statute and, Prince George's County ordinances and really making sure we put ourselves in a great position from the beginning to be successful. So I think that's my thought. And thanks again, Scott.
Jay, thank you. Jose, final thoughts.
Yes, just wanted to point out something to everybody. If you're representing a person who wants to file discrimination in the county in employment, it's the time to file with the office is 300 days. I know that it's on the statute, it's 100 and it's showing it's still 180, but based on the state law, it was changed to 300 for FIPAs in the state. In that's employment, everything else in the ordinance, that is public accommodation, in commercial real estate, that is 180. But another thing, just finally, I think just see us as we are. We are a neutral agency, just trying to look for what happened. So please don't see us as your enemy.
Jose, thank you. Renee.
Thank you. To carry on with what Jose says, yes, we are neutral, but we are a resource. We do training for free. Know your rights as an employee, know your responsibilities as an employer. So if there's ever an event or a place that you would like us to come out, we do that because honestly, we would rather not have people come in and see us with employment problems. That's the goal, right? We're also a resource for free training for human trafficking awareness, labor trafficking. As you know, you can have legitimate employers who unknowingly or unwittingly have people that are actually trafficked in labor through a third party. So please remember that. Also, one final thing is under employment, we have the authority to investigate ban the box. We haven't really talked about that, but ban the box or fair labor practice is something that employers cannot do in terms of asking about criminal records, criminal background. There are exceptions, but we can certainly come out and train on what that is. So thank you very much for having us.
Renee, thank you. Judge Killough.
Well, thank you, Scott, for having me. I thought it was very useful. When you get to me, the case has been going on for a while. You've filed your complaint. You either won or lost your motions to get rid of the case. Probably in the case of the defendant, you lost the case. You lost your motions to get rid of the case. Mediation has failed for whatever reason. Your plaintiff's lawyer, maybe because your client's expectations are such that settling was not possible, whatever the reason. There could be frustrations. You've had discovery disputes. You've had arguments. That shouldn't bleed over to the trial, though. You're at the final. The demeanor, I think, is the most important thing. That's what I'll leave with you. Is unfortunately, I see a lot of trials where there's a lot of, I think, pent up frustration that sort of bleeds over. I don't think that inures to your benefit. I think demeanor, professionalism, be courteous, be cooperative. You're at trial at this point. There's no point. You're not going to win any. They're not going to have any. There's no point having disputes about stuff that's already occurred in the past. So at this point, the most important thing is convey your message about your case. What is your case about? What's your theory? Why do you believe that the jury, in the case of an employment case, why do you believe that if you're the plaintiff, that your client was wrong, and if you're the defendant, that you've been unjustly accused? But I think demeanor is the most important thing once you're before me. So that's my last thing I want to add. Thank you very much for having me.
Oh, you're welcome, Judge Killough. Thank you for being with us. Michael, final thoughts.
First of all, I just want to say I'm not an employment law practitioner generally. So this has been a learning experience for me. And I just want to thank everyone for attending and thank our great panelists. I know a few of them personally, and it's great to see a peek into the employment law bar in Prince George's County.
Thanks to Judge Peter Killough, Renee Battle Brooks, Jose Villegas, and Pamela Ashby for participating. in today's program, and a special thanks to Jay Stafford, who organized this webinar for us. Thank you too to Michael Adams and our co-sponsor for today's program, the Prince George's County Bar Association. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's next Bench Bar Committee webinar on March 7th at 12 o'clock Eastern. The Virginia Human Rights Act, prosecuting claims administratively and before the Fairfax County, Virginia Circuit Court. For all of our programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.